The broadcast is now starting. All attendees are in listen-only mode.
Hello, everyone. Mike Volkov. Good morning, good afternoon. I want to make sure that everybody can hear me okay, and you have the slides in front of you, and I uploaded the slides, so you should be able to download them. But we're going to talk about trade enforcement today, sort of a review of the year, and where we go from here. This is probably the number one risk that everybody is facing today. And I would say that imports, exports, you have serious risks on either side of the equation. And we're going to talk about that and review that. And obviously, people already know this, but I just want to emphasize and sort of highlight some of the risks that are out there, and also, try to get to some of the solutions. But that's probably the subject of another webinar, to be honest with you. But I'll try to, provide some helpful ideas, guidance, things to look for, how cases get started, and other things like that. I'll try to take questions along the way. If I don't, I'll probably write you afterwards if I don't get to it, but I will try as best we can. But welcome, everybody, and hope everybody's having a good year so far. Let me sort of start with the headlines, and I want to make sure everybody can see. Let me know if there's any problem with regard to sharing the screen or anything like that. But let's look at the trade enforcement. What are our headlines? Number one, it should be a top priority. It's got to be within your top three. Look, everybody has cybersecurity in there, but in terms of it's kind of replaced, corruption, anti-corruption, in terms of a top priority. We have the DOJ really starting to take the lead here in putting together a trade compliance approach and a trade enforcement approach that focuses on sanctions and export controls. But really, I think on the import side, we have False Claims Act cases that are now being brought for tariff and duties circumvention, meaning you better make sure you're paying, the accurate amount of duties that are owed when you're doing imports. OFAC sanctions, obviously regulatory risks here are still strong. The biggest thing to me is that DOJ is taking the lead, and I'll show you examples of how they're doing that. Customs and Border Patrol, CBP, is now like a full-fledged regulatory partner with DOJ in this area. So import duties and tariffs, export sanctions and export controls, mergers and acquisitions, and integration. If you're acquiring assets or a company, please make sure you integrate and you conduct a post-closing audit. We've done those for folks, but they're really important as a sort of check on your system when you acquire companies, or if you acquire companies that were not subject to U.S. jurisdiction, foreign companies, but also to the extent they were, then what kind of program did they have? And, do you have any potential violations? So those are our headlines. We're going to go through, I've got stats for you. I've got other things for us to look at as well. And I like to put it in, lions and tigers and bears, oh my, but trade enforcement, tariffs and sanctions, and export controls. And tariffs are particularly difficult because they change. They're changing. They're always in a state of flux these days. Threats are made. Then maybe they're carried out. Then there's maybe a reduction in the threat amount. So you've got to be careful with this. But the other thing that is going on is that DOJ is developing really effective communications with the regulatory agencies, coordination, and taking more and more of a leadership role. And this is where they get resources. This is where the National Security Division uh, plays like a central role in this area, along with part of the criminal division or the civil division, even though that deals with False Claims Act. So we'll talk about that. But the underlying key to all of this is national security. And we've seen a confluence over the years of national security concerns from DOJ's perspective and criminal enforcement. And for businesses, this is where the rubber meets the road in terms of your trade enforcement program. It's got to be robust. Please re-examine it. Do whatever you can internally to try to maintain the focus on this. Train on it. Make sure your businesses are really aware of this sort of environment, because I think the next few years are going to be very interesting in this regard. And that is and I talked about, so you have the National Security Division, which prosecutes sanctions and export control cases, whereas you have in the Civil Division and the Criminal Division, if it rises to that level, and it did in one case I'm going to show you, that False Claims Act cases are brought by the civil enforcement group that handles False Claims Act in general. So resources are allocated to national security. One other point is if you're in the banking industry and you're particularly if you're working or interacting with global banks, there is an additional and another push being made to go back to the days of pursuing sanctions violations involving global banks. So the Banking Integrity Unit, which is part of the money laundering section, which is in turn part of the criminal division, I know it sounds pretty crazy, they are pursuing and have been instructed to go after some of the global banks to make sure that they are not hurting the overall objectives of the sanctions program. So this is something, and remember years ago we had a lot of the global banks got in trouble. These were foreign banks, based, let's say overseas, but nonetheless operating throughout the world and including the US, and they got in some serious trouble with regard to sanctions compliance and sanctions enforcement. So you're going to see that come back again, and you got to be mindful with regard to this as well, this area. So we are seeing DOJ's elevated role, coordinating this, creating relationships with all the regulatory agency, Customs and Border Protection. We have Bureau of Industry and Security from the Commerce Department for export licensing and controls, OFAC, which we all know about, and the State Department with ITAR enforcement. We haven't seen any increase with ITAR. I don't know how high a priority the DDTC is with regard to enforcement at this point in time, but we have seen the other three regulatory agencies very much involved with DOJ. And this is an aggressive strategy that's linked to national security, foreign policy objectives. False Claims Act, obviously, is tariff and duty evasion, and people who, are trying to circumvent these as well to try to get to, reduce their costs in bringing in items. At the same time, we're seeing the message with regard to imports and forced labor protection, which I'm going to talk about, is kind of equivocal in that area. But if it involves money, it's definitely something that the government is after. So we'll talk about the Force Protection Act in a minute. Look, it's always hard to have a slide that says tariffs update because they change. all the time, and what becomes a priority, whatever. South Korean tariffs actually just got raised from 15 to 25% because of South Korea's delay in ratifying a deal that was made in 2025. We still see some reciprocal tariffs. Obviously, there was a reciprocal tariff announcement in April of 2025, and those deals are still being sort of passed through the system, negotiated through the system. The Supreme Court's case with regard to national security authority and tariffs is still pending. And the question, it'll be interesting if they reverse or if they hold that the tariffs, that the administration does not have the authority to impose these tariffs unilaterally without congressional action. I suspect they won't. They will uphold the administration's ability to impose these tariffs, but we'll see. Now they're starting to focus on tariffs for countries that supply oil to Cuba. They've threatened 50% tariffs on Canadian aircraft, goods. It involves a dispute involving Gulfstream. And obviously, there's a huge host of tariffs imposed on Chinese goods across various industries that since day one of this administration we've seen. Steel and aluminum still have 50% tariffs imposed on them for imports, and auto parts are at 25%. The effective average tariff for U.S. imports about 16 to 18, with as high as projected as 21%. Now, the key question from last year was how much of this was passed on to the consumer and how much did the companies eat? What's interesting, I think, is last year the companies ate a fair amount of the increased cost, but I think now they're starting to pass on a little bit more. But they're still, taking in some of the increased costs and not necessarily passing it to the consumer. So that's always sort of something to watch, and it probably obviously varies by sector of consumer goods. Okay, let's talk about DOJ. In DOJ, you have to now break it down into two areas, believe it or not. It's not just sanctions and export controls, it's false claims for tariff and duty circumvention. We'll start with the first, but the priority on trade compliance is very much a priority. Tied to national security with the two areas that I've mentioned. And now we're starting to see not only in the False Claims Act area do you have a whistleblower program, and the cases that I'm going to show you involved whistleblowers, but DOJ's whistleblower program has been expanded to include trade compliance issues and payment to the whistleblowers. Interestingly, of the, I think, 6 cases in the False Claims Act area that we're going to review, 2 were brought by whistleblowers who were competitors. And this is an important trend to watch because now competitors have, and they sometimes can figure out enough information or get access to enough information to lodge a complaint, particularly with regard to imports. So 2 of the 6, and years ago I represented a whistleblower company in regards to the tungsten market because there was a company that was illegally importing tungsten products, which is highly competitive, into the United States. And the whistleblower complaint led to a recovery for them, but also the prosecution of the CEO of the American company who went to jail. So this is now a new and really growing risk, which is the ability of competitors to go in as whistleblowers and companies and earn a recovery and bring an end to to what could be otherwise illegal activity by somebody in the market. So that's an important thing to watch as well. The roles of DOJ with their regulatory agencies is very, very good. It's well established, but it's even more coordinated, almost to the point, like by analogy, we all remember, the days of the FCPA being duly enforced by DOJ and the SEC. Well, we're getting to that same point with regard to OFAC for sure. Bureau of Industry and Security is growing, but we've seen Customs and Border Protection as well. And in the past, we've seen DDTC situations, but we did not have one in the last year where DOJ was involved or that there was a regulatory prosecution. So the other important news is the Trade Fraud Task Force. And that's where this False Claims Act on imports is focused. And they've already had results. They had 2 big cases in the end of December. And I'm going to show you those. And that's what I'm saying is we're going to see more and more of those types of cases. And they're going to be larger and larger fine amounts. And so DOJ is poised. They know how to do these cases because they structure them in the same way that they structured FCPA with, a guilty plea by the company or a deferred prosecution agreement or a non-prosecution agreement, and then extracting penalties and fines and disgorgement. So the twin hammers that we see now are the criminal cases that are brought by DOJ in the lead, and we see the False Claims Act. These are 2 hammers that they have, but look, just break it down like this. Exports, you're subject to sanctions and export controls, and if you have military items, obviously the State Department. But imports is now a False Claims Act priority in terms of tariffs and duties that can occur. Now, as a result of this, we've also seen, I think, a little bit of a change in attitude at the Department of Justice and the new sort of corporate enforcement program, which tilts even more to voluntary disclosure. Why? First off, at DOJ, it's very clear now that if you voluntarily disclose, cooperate, and even with aggravating circumstances, you're not going to get a corporate monitor. But secondly, you're going to get a declination. In other words, you're not going to have to plead guilty. We've seen non-prosecution agreements. There was only one case last year, which is the most significant case, Cadence Design, but that involved a Chinese company and also involved some serious violations where the subsidiary was forced to enter a guilty plea, but they did not cooperate in the same way that other companies have cooperated and earned right away. The presumption, if not the almost guarantee right now, is if you disclose, cooperate, remediate, and disgorge, you're going to come out of this pretty clean. And they're probably going to go after individuals. We've also seen that, and I'll show you that in the White Deer case where they went after a CEO who was responsible for a series of sanctions violations. So voluntary disclosure in this area is a lot different than it is in FCPA context because you're also dealing with regulatory agencies that you need to depend on. And by that, let's say BIS. Voluntary disclosure is usually going to be the way that you go with regard to BIS because you want to be able to get licenses that are essential to your business. OFAC, I would urge you as well because they have a very I've been in almost every situation where I've had OFAC violations. We've ended up voluntarily disclosing, remediating, and not having any serious penalty imposed. in the first-time offenses. So there's even more greater sort of incentives and structure for this type of handling of potential problems. And what makes it even more complicated is that you may end up voluntarily disclosing not only to the agency, but also to DOJ. And you voluntarily disclose when there's some evidence of what's called willful intent, and I'll talk about that. But OFAC has a general voluntary disclosure rule, which gives you 50% credit right off the bat, and then with more reductions available to the extent you cooperate, remediate, agree to certain remediation tactics to make sure it doesn't happen again, and enhance your compliance program. Now, on the DOJ side, obviously, I told you already, you're going to get a declination, but when you have evidence or there's suspicion that it may have been intentional with willful intent, then you're going to lean towards also disclosing to DOJ. So I had a case where, on the other hand, where it was clear it was an error made in providing goods to an Iranian company. They thought that if they shipped it from the US to Canada and then from the Canadian subsidiary to Iran, that it was not a violation. Well, it was a violation, but it was all done, and there was no evidence whatsoever that the individuals involved knew or had any reason to believe what they were doing was illegal. So in that case, that was a voluntary disclosure to OFAC with remediation, training, and other things that were important to do. And there was no reason in that case to disclose to DOJ because there was absolutely no potential evidence that there was willful intent. I think, but given DOJ's attitude these days, I think, that's always something to consider depending upon the evidence, unless it's clear one way or the other. So I mentioned willful violation if done with knowledge that the conduct is illegal, not that you know the specific provision, the Iran sanctions, et cetera, it is that you have knowledge that the conduct may be or is illegal. So you don't have to know the specific law or regulation. It goes back to a case, Supreme Court case called Bryan, and that was in the context of the gun regulations and whether or not you knew that a regulatory crime you were engaging in was illegal conduct as opposed to the specific law or regulation that you were violating. Now, from DOJ's perspective, we see, and I track pretty much the sanctions, export controls, ITAR violations. In 2025 was a slower year than 2024, which was a big year of 70 cases. Now, these are individuals, companies, and I think the reason for that in 2025 is whenever you have a transition in an administration, you'll see it sort of go down a little bit because it takes a while for things to get going, getting the political people in place to get cases signed off on and you go forward. I think 2026, this number is going to go up and we're going to be in the 70, at least the 70 range this year. And there are a lot of cases. You can see these cases coming out of all jurisdictions where you see individuals who are prosecuted for trying to circumvent sanctions or doing things without complying with export controls. Oftentimes, and I'll show you another, I also keep track of which countries are involved with the illegal exports or sanctions. And notice you have Russia, you have China at the top. I was surprised that Iran only involved 5 cases, but I think you're going to see more of that depending on what happens in the current state of negotiations with Iran. but it was clear that the government, in response to the unrest in Iran, intended to increase sanctions and to go after the Iranians with even tougher sanctions. I mean, they already have very, very tough sanctions to begin with. I'm not surprised by China and Russia, Russia being the top, where imagine you're a company and your goods, you say we're not dealing with Russia, but you find out that on the battlefield, your goods are being, recovered and identified by the U.S. government in Russia and Ukraine in the war. And that is really not a good thing, but it goes to how do you regulate your third parties? How do you regulate your distribution chain? And it was interesting to see Haiti make it, and that's probably because of the unrest that's occurred there. And we had a couple of cases in Venezuela, but we'll see. We've got a new, we're waiting on sort of the resolution in Venezuela of their negotiations over the sanctions scheme and what's going to happen there. But anyways, just an idea of how these criminal cases are working. Now, I want to give you two cases that show you the DOJ model with the Cadence Design and Unicat, where they work with the regulatory agencies, but it looks like a quote-unquote FCPA-like case, and they work with the regulatory agencies like they would work with the SEC. And Cadence Design Systems was a big case. It was a criminal fine of $140 million, working with BIS, and BIS taking regulatory fines. And this was a series of exports against Cadence, a California company that was providing this design automation technology that was used, and they sold this hardware, software, and semiconductor design to a university in China that's controlled by the military. It's basically a front for the military. And they sold this, and they knew about the prohibition against these sales going back to 2015 in terms of the Department of Commerce's entity list. And the National Defense Technology, the Chinese university was running models on supercomputers about nuclear explosions, military simulation, but this was what Cadence was providing and supporting. Now, what made it worse for Cadence was the fact that they conspired. Basically, they knew they were supplying it. There were individuals who knew, and they used an alias company. And then they used, when that alias got named, they then used a third party. And they knew that the Central South CAD Center in China was an alias for the prohibited entity, but nonetheless, 59 separate exports went there. When they were added to the entity list, the compliance officer emailed everyone and saying that export licenses now are required if sales are made. First off, they wouldn't have gotten the export license. But second off, this is a prohibition. But there were documents within the company that showed that Cadence's subsidiary in China and the employees there knew about the prohibition, and they tried to circumvent it. They then brought in a third party and FITEM. And this just shows you that, and then eventually FITEM got designated as a way to stop this. But this was a continuing course of conduct, for over, 6 years. And so this doesn't surprise me that you had 140 million. What's surprising to me is that there were no individuals indicted, and it may be because of statute of limitations issues, or maybe who knows what's still going on in connection with this investigation. But notice you have BIS working closely with DOJ in bringing this case, And there was a guilty plea that Cadence had to enter to a conspiracy to violate. Um, and uh, and so and then there was a regulatory settlement as well. The paperwork looks the same like an FCPA case with regard to remediation and cooperation requirements. This case, Cadence, is the model of what's going to happen in these situations when you get the company that's so involved or so aware, as opposed to, let's say, a single individual circumventing rules and regulations as well. The other interesting case was Unicat, and Unicat involved a situation with an acquisition. Unicat, now this was coordinated by DOJ. There was a non-prosecution agreement and a payment of 3.3 million, but OFAC and BIS and CBP also got into this as well. So this is the first appearance of CBP in a case like this, but this resulted in this was the result of an acquisition. So White Deer, and I love the facts of this case, White Deer acquires Unicat, and while the CEO of White Deer is over at Unicat, okay, inspecting the facilities, the new place, their new business, their new assets, all of that, he sees that he actually witnessed them or saw paperwork involving transactions to Iran. And these are chemical catalysts that are used in oil refining at Unicat. And basically, the CEO was the one who said, uh-oh, you got to stop this right away. And they immediately disclosed it and found out that Unicat had been falsifying documentation and had been evading, but they immediately cooperated. Once they were acquired, he identifies it. The CEO of White Deer identifies it. Unicat immediately complies as a subsidiary now of White Deer. And they disclosed and voluntarily disclosed. And then they built the case going after the former CEO of Unicat, who was running the whole Iran initiative. But they were sending materials and paperwork through the Netherlands and an affiliate, and then they used my always favorite thing is to see a Dubai distributor. I tell you, if you're sending stuff to Dubai, it's a launching pad into Iran. But everybody knew they were doing, even the board and senior management knew the company was doing business with Iran. They were aware of it. But because Unicat immediately complied once they were acquired, helped to prosecute the CEO, there was DOJ ended up not just entering a non-prosecution agreement, getting the disgorgement and prosecuting the CEO. So again, you had a course of conduct over several years, but this is again another example about the importance of merger and acquisition, acquiring assets, and making sure you get on top of that. So now let's switch to the False Claims Act. We've done the criminal, the FCPA like. Now we're going to look at traditional FCPA, False Claims Act cases that are all of a sudden with qui tam relators dealing with import risks and circumvention. So DOJ launched this task force in August of 2025. And I'm going to show you a couple of cases that they've already brought, which one was a record breaker in the trading area, in the tariff area. So whistleblower suits. The other thing that's interesting is that cooperation here in the False Claims Act area, it's existed in the past, but here it's kind of like on steroids in the sense that they handed out some very beneficial rewards for cooperation in a False Claims Act case. And I'll show you that as well. But What DOJ is saying is, look, do proactive audits of your import practices, remediation of regulatory irregularities before they attract, an investigation of some sort. Remember, you're dealing in a whistleblower world, and there are lots of lawyers out there to represent these whistleblowers, and that's what they want to do, is to bring these cases. So they brought they brought a total of 6 cases, and 4 of the 6 involve claims of circumventing anti-dumping and countervailing duties, which you're well aware of in the industry. If you're in it, you'll know that there's a dumping case and what duties have been imposed to try to equal things off. But remember, for 2021 to 2024, DOJ had only 2 tariff-related FCA cases, and now they've had 6 already. And I'm just saying we're going to get many more as time goes on, because by December we started to see multi-million-dollar settlements were more common. The biggest being a $54 million case DOJ brought against Ceratizit, and we'll talk about those cases in a minute. Allied Stone, Harman International, and criminal charges were brought against a company executive. So that was the second criminal case this year against an executive. The first was against a jewelry store owner, but the second was against the chief operating officer in the MGI case, which I'm going to show you in a second here. So this is what is the new reality with False Claims Act cases. What are they looking for? They're looking for failure to pay duties and fees, false paperwork as to country of origin, as a way to evade. In other words, instead of saying it's from China, you say it's from Taiwan. And valuation, classifications under the HTS codes, misrepresentations as to valuation. Remember, you have a whole host of regulatory requirements in terms of record keeping, and you're using licensed custom brokers, which raise third-party risk issues in the import context. So misclassification, underreporting, failure to declare, circumvention of tariffs, and even importing from sanctioned parties can be that. Here's the sign. This was at the end of December. This was announced as a $54 million case where there was misrepresentations as to the country of origin for tungsten carbide products, tungsten rods, when they claimed Taiwan when they were actually Chinese origin. And they had misclassified HTS codes for years. $54 million. MGI International was a global plastic and fraud case related to plastic resin imports, falsely declared the country of origin. Here, what's interesting is DOJ declined the criminal charges against the company because of voluntary self-disclosure, cooperation, and they paid a $6.8 million penalty. But the chief operating officer pled guilty to conspiracy to smuggle when he instructed his subordinates to misrepresent the country of origin, again, as not coming from China, and is now facing 5 years imprisonment. He's anticipated to get 2 years. Now, notice the language that I quoted here in terms of remediation, termination, and disciplinary action. This could be an FCPA case. Employees involved in the scheme and the misconduct and internal review, internal controls, a root cause analysis, and an enhanced compliance program. So this is just a reminder. We need to button up our trade compliance programs, and we need to be monitoring this process and the internal controls that go with regard to taking imports. Sample is the way to go, sampling, but we have to be monitoring these because you're looking at criminal and civil prosecutions. Allied Stone, interestingly, here in this case, They evaded anti-dumping countervailing duties for quartz surface products, our good old countertops. But who was on the hook? Not only Allied Stone, but the president. The president of the company was required to pay millions. It was a joint liability type of thing for 12.4 million. And we had false labeling of products to avoid duties. In other words, they called it marble or glass to avoid the quartz surface product code. And again, this is something that is easy to carry out, but really has huge implications. The theory behind the False Claims Act, and I think it's pretty solid, is reverse claims provisions where you're avoiding or reducing an obligation to pay money to the government by submitting false records or improperly undervaluing goods. The other three cases that I wanted to point out here was evading, again, Harman International had to pay 11.8 million, Evolution Flooring 8.1 million, and Gross Felix 4.9 million for misrepresentations relating to furniture parts. So these are the case. We're going to see more of these this year. And because the Trade Task Force is gearing up, they're also going to be coordinating with U.S. attorneys' offices and port cities, and you'll see more and more of these types of cases being brought this year. But an important reminder in terms of the import and fees that have to be paid. So that's DOJ. That's just DOJ. We haven't even gotten to the traditional presentation I used to do, was mainly on OFAC. And I would go through OFAC cases. Now you can see, because DOJ is elevating its role, here we are, slide 32, and we're just getting to OFAC. And that's what I mean in terms of this is a new era. This is the board, your audit committee, your senior executives need to know. This is what is called board-worthy information as to what DOJ is up to in this area and what they plan to do in terms of ramping up enforcement. So remember our sanctions schemes, just a reminder slide that we have comprehensive, which are countrywide. We have selective, which are SDNs and individuals and entities. And then you have purpose-based, and we still have the remnants of sector-based in Russia from the original sets of sanctions in 2014. But these are our sanctions regulatory schemes. We've seen some changes, obviously, and you have to monitor this. Everybody is waiting for Venezuela to be relaxed in some way. We already have proposed licenses. They're still moving the effective date during these negotiations. But Syria, for example, those were relaxed. But we still have ongoing specific programs that impose, strict prohibitions involving Russia, involving Cuba, North Korea, Iran, Belarus, and Myanmar, which is back on the list. So these are, your key ones to keep focused on. Syria has been relaxed, but Venezuela is definitely going to be relaxed in one way or another. It's just a question of how quickly it's done. The number of enforcement actions was not, in 2025, was not that significant in terms of only 14. So it was a moderate year for OFAC enforcement. Again, you have a new administration coming in. You also had a lot of resources dedicated to administering sanctions programs or relaxing them, as we've seen. But there, is continued sort of use of sanctions as an important tool of our foreign policy. And that led to, I think, some use of resources and the fact that it's a new administration. But I expect this number to go up again in 2026 once you get past the first year of a new administration. And you can see the total fines were in the 200s, not a huge year, but these years of 23, 19, Those, and if you go back to 14 and 12, those are with big cases where you had, let's say, a global bank involved or something like that. So this past year, what's interesting is, and I'll go through the summary of sort of the enforcement. I'm not going to do a case by case analysis, but these are the 14 OFAC cases that were brought and the amounts involved. And I'm going to give you a little bit of a summary in terms of these uh, cases. They didn't cut across industries as much as some of the cases did in the past, and where you'd get logistics companies, you'd get other, crypto companies, things like that, where you'd get a variety of sort of industry participants who got caught up in OFAC cases. In fact, what you saw were that the significant cases really involved people who were carrying out, executing transactions secretly or attempting to be secret on behalf of Russian oligarchs. So the three big cases were Family International, GVA, and Gracetown. So you can see those back here. Family International, but Gracetown, but GVA, was a big case, 215 million. So then we have two cases against individuals with significant penalties that I will show you in a sec. The Haas case involved a Russian distributor. And then we had the Key case, which involved the acquisition of a foreign company and continued sales to Cuba, just like I was talking about in terms of screening and the importance of post-acquisition audits and things like that. We had one online brokerage case involving transactions with Cuba, Syria, Crimea, and violating the Chinese military restrictions, Syria and Venezuela. And then we had one case which was sort of in the crypto digital asset area, Exodus, where even the customer support was telling people to use VPNs to avoid detection for Iran customers from their IP addresses. In other words, to access their digital asset exchanges through their wallet that they offered. That was the service that they provided. So this is sort of a summary of the highlights of what was occurring and in terms of the types of cases that were being brought. I think we'll see again a broader hit or complement of cases in the current year. Now, there were two individuals who are not named, but two settlements, and connected to Russians again. So here we had individual number one. These are two separate cases who had to pay 4.6 million. Now, this individual mortgaged, renovated, and sold a residential property, I think it was in Florida, owned by a Russian SDN, no voluntary disclosure. Individual number two in December, 1.9 million, 122 violations, running a family trust for a Russian oligarch, and not Niet or Noi, but not disclosed, but cooperated. Now, why are there not voluntary disclosures? In these cases, the way these cases get brought, and you all know this and won't be surprised, is the banks have their obligation as the front line, the first line of defense, and will block a transaction when they're not satisfied. The current trend that I've seen with regard to banks is they're over blocking or being extremely careful. And sometimes even when being told that or even provided legal presentations, they still will say, we're not going to block this. We're not going to let this transaction go through, but they don't find that it's a potential violation, so they don't report it to OFAC. When they block, they report it. And when they report it, if you get into a blocked situation, voluntary disclosure is you do it right away. You do it right away. And then you can argue with OFAC as to whether or not you voluntarily disclosed, knowing that the bank had already disclosed it. But nonetheless, it puts you in a position to try to catch up as quickly as you can and cooperate. But remember, the banks are scrutinizing, and I've seen just more and more assets and attention paid to this because the banks were hit years ago. A lot of banks were hit, and the banks are getting more sophisticated in their monitoring techniques. They're getting more sophisticated and more conservative in their judgment calls. So be careful with regard to banking transactions that occurred. Okay, so we'll switch just a little bit to talk about commerce and BIS in terms of what occurred in terms of enforcement. We had some criminal prosecutions noted above. When I talked about DOJ, and some of those criminal prosecutions involved BIS. What's interesting in some of the cases I'm going to point out to you here is these were EAR 99, and we all know that those are unregulated products under the EAR, but were nonetheless violations involving EAR 99 products that were covered by the HTS codes. And remember, this has become a difficult area, and it came up during the Russian sanctions, and it's come up in this area where you may have an EAR 99, but it may be covered by an HTS code such that you do need to get a license. So be very careful about that. So in this case, Andritz, the company, was illegally exporting refiner plates to its German affiliate that in turn then shipped it to Russia without a license. But it was covered by an HTS code, and they ended up paying $1.57 million. Now, the Alpha and Omega semiconductor case, $4.25 million, involved foreign-produced semiconductor components, but we're going to Huawei. And Huawei, we all know, was nobody should deal with Huawei. And these guys violated that, but nonetheless ended up, and these were foreign-produced semiconductor components that had sufficient U.S. ingredients or inputs to make it subject to the BIS regulations. And we had that as well in the British Virgin Island case here, which is 374,000, but the re-export of a Bombardier aircraft, which is from Canada to Russia, where there was more than 25% United States manufactured parts in the product. So remember that BIS regulation goes with the product, not the person. If the product has enough U.S. origin material in it, then, and it's subject to U.S. regulation, that's where the liabilities come in. Okay. I mentioned already Haas and Cadence Design. Those were two cases. And then we had another EAR 99 item, a Canadian company that had to pay $685,000, which EAR 99 items, but nonetheless were covered by HTS codes. So, and the Commerce Department went around, representatives in the beginning of the year saying you're going to see more regulatory fines, higher regulatory fines, and more criminal prosecutions. And in some sense, when you put DOJ and Commerce together, that's what you've gotten in terms of more criminal and increased regulatory. And you're going to see more and more of this as well. Every agency here is ramping up with assets, with resources, and that's going to result in increased prosecutions. That's just the rule of thumb in this. Now, I mentioned the Forced Labor Act, and what's interesting, there was a Wall Street Journal article, if you saw it, where Democrats were complaining about a lack of vigorous enforcement, citing a reduction in the total value of detained shipments. It's an interesting, I don't know the proper way to calculate because they had a higher number of detained shipments, but the value of those detained shipments was, 200 million versus, a billion in 2024. So the article, and also we have the Democrats who are writing letters saying you guys aren't enforcing this. But at the same time, we've had the prohibited entities expanded, and we've had new designations of priority sectors involving steel, and steel is a big one in China. So be very careful if you are ultimately purchasing from a steel manufacturer in the U.S. You need to know, or let's say in another country, in China, or what I'm not in China, but in Japan, you got to look at their supply chain to see what they're using, if anything, of inputs from China. Copper, lithium, caustic soda, and red dates. You already have apparel, cotton, tomatoes, polysilicon, obviously from the solar industry, aluminum, and seafood. So all of these sectors are subject to this. So I'm not sure where the truth lies in terms of the enforcement approach. The article was suggesting that there was sort of a relaxation of some of that. I'm not sure if that's true with regard to the amount of money that's being detained, whereas the number of shipments that were detained at U.S. harbors and triggering the requirement of the importer then to demonstrate that the imports are not from the prohibited forced labor areas. So just a couple of reminders. If you're going to go back and look over your policies and start to, get things in shape, start with an overarching trade compliance policy, which covers dual use, sanctions, let's say, ITAR, if you have that, anti-boycott should be included as well. But you need to have a master sort of overarching trade compliance policy with procedures underneath it in terms of manuals that the regulators want. For example, Commerce and BIS, they want to see the manual that you have for dual use items. And that's where you map out the policy and take it step by step. But you start with your overarching policy. Please do a new risk assessment. Look at your import and export risks because you have limited resources and you want to make sure that you're addressing those. You can't just depend on the business to run a screen before they ship a product out. Screen your suppliers, your logistics partners, make sure you have controls in place that no one single person can resolve that. Annual audits, absolute must. I've seen some companies now that are doing monthly sampling of their imports and exports to look at the transactions and double check them and do it by a sampling process. A terrific approach by this company that we were working with, and we love the sort of sampling on a monthly basis. And it was carried out, and it was really quite effective. And a real difficulty now is monitoring tariff changes, rulings that come out, new duties that are imposed, and new tariffs that are imposed as well. Remember your third-party risks. These are just huge in trade because your distributors, agents, from a regulatory standpoint, a distributor, if you know or have reason to know that a distributor in Dubai is going to redistribute, retransfer to Iran, you are then on the hook. And then you become in that situation with the voluntary disclosure, trying to figure out what did we know, who did this, and why. So please, you use your contractual provisions. The most significant expansion I've seen in this area is in the use of end use assurances and documentation. But that has to be done on a risk basis. You cannot just say, okay, we're going to do this in every case. it's really difficult, and some distributors will resist it because they think you're just trying to get information about the customer so that you can circumvent them. But in high risk situations, we've got to try to get those end use certificates. Sometimes the distributor gives it to you. You need some documentation to protect yourself in these situations. So please be careful. Um, and I always say, like I just mentioned, focus on your high risk third party risks. So, for example, into Dubai, look geographically where you're going into Dubai, into Turkey, into transshipment risk points, Eastern Europe. In China, you look up north because you're worried about Korea and inputs that can be coming in from Korea. And you need to use as much of your tools, the ones that you all know, and to collect, analyze, review data, and monitor your operations to make sure you don't get hit with, oh, by the way, the bank won't do this payment in China or involving a Chinese company because of X, Y, and Z. Anticipate those issues, prioritize, conduct a focus on the risks. Now, these are some of the compliance enhancements I mentioned. And do not forget, you are required annually to conduct sanctions training. That should be done, not for everybody in the company, but should be done for people who are responsible. In other words, people who come into contact with this issue. Sorry to run a little bit long, but we have a lot to cover. Again, stay in touch and let me know if you need help in this area. We're happy to help. I'm going to launch the poll here. And if you want a copy of the slides, please email me if you couldn't download them. Second off, also, I will post this recording and I'll post it on our YouTube channel. Stay in touch, but we can definitely help you in this area. We're working, I would say, probably 60 to 70% of our work now is all in trade compliance in particular. And so this is just a big risk right now, and we urge you to take a look at that. And if you have any questions or follow-ups, please feel free to reach out at any point in time because we want to make sure that we can, help you get through this. It's a tough time in terms of trade enforcement, and I think, but we're up for the challenge because we've done this before, so I'd love to help you, support you. We have samples of lots of things. Please stay in touch. And we'll be back. Probably I'm thinking of doing another webinar in the trade compliance area with even greater focus perhaps on False Claims Act and how we get at these issues with regard to circumventing duties and all of that. So be good, everybody. Stay out of trouble, as I always say, and we appreciate the support, and we'll talk to you soon.